Well, let me come back. I didn't want to come back to this concept of what is free speech. We all, it's something that Americans identify. It's the First Amendment, although I think when Madison wrote the draft Bill of Rights, it wasn't the First Amendment. I think it was the Third Amendment, but I think it was the first two that didn't get approved. So what was third became number one. Correct. So I think somewhere internally, most Americans say, aha, the First Amendment, the reason it's the First Amendment is because it's who we are. It's our basic essence is the free speech. That's who we are as Americans. And that's why so many Democrats and Republicans, I think, can agree on the concept of free speech, because that's really deep inside. It's not so much a political issue, it's a statement of our identity. So we come to this free speech, but the First Amendment, I think it says something along the lines of Congress shall make no law respecting or prohibiting free speech or...
make no law abridging the freedom of speech or the press.
Or the press. So it's Congress. Yeah. But it's far broader than that now, isn't it? Because it applies to the government, not just Congress. So how did that come to be? What I'm looking for is our current concept of what free speech is from its infancy to our current concept, because that's, to me, in the First Amendment, it's actually very narrow language. It says Congress. It doesn't say the United States government or anything of that nature, but it certainly has grown over the centuries. How did we come from that point in the First Amendment to where we are now with the concept of free speech?
Yeah, so the original First Amendment was, I think, and Akhil Amar from Yale argues this, and I think he's right, it was mainly designed as a federalism provision. So the whole Bill of Rights was meant to further limit, there was a lot of concern that this new federal government that was being authorized by the Constitution, there just weren't enough structural limits on its power and its ability to grow vis-a-vis state governments and people living in various states. And so that's why they demanded a Bill of Rights, to put more limits on the power of the federal government. And that's why the First Amendment says Congress shall not, if you look at the necessary and proper clause in the Constitution, it says Congress may make any law that is necessary and proper to carry into execution these foregoing powers. And so this was the counterpart to Congress being able to make laws. Congress shall make no law abridging the freedom of speech or the press. So it was mainly designed to say, Congress, you're supposed to deal with the national economy, national defense, not domestic issues like free speech, freedom of religion. That's for the states that have historically governed these issues in their respective states, their state governments to do. So it was basically a hands-off. You stay out of this area.
So you're saying then the attitude was the states can restrict
and
free
they did.
speech, but not the Congress.
They did.
So that's a state federal government issue, not a personal rights issue.
Correct. I mean, state and local governments, there wasn't a lot of free speech. It all depended on, in the founding era, it all depended on sort of the state and local laws that might govern it. And I think there's a lot of recognition that free speech is really a modern concept. As late as 1919, World War I, people were being thrown in prison for opposing Woodrow Wilson's involvement of America in that war. And they were going to jail for lengthy prison terms of 10 to 20 years. And the Supreme Court, said, hey, it's wartime. You can't protest the government's war policies. You can't interfere with that. It's something that would be unthinkable to us today, and that was just 100 years ago. Yeah. And it wasn't, it was really Justice Oliver Wendell Holmes Jr. that got the ball rolling in his powerful dissents, and Louis Brandeis that would join him in these dissents to say, and Holmes had an epiphany. Originally Holmes was on board with just affirming these convictions of these protesters going to jail for their speech. But he had an epiphany the summer of 1919 when he had certain conversations with Zachariah Chaffee, who was a Harvard law professor that was a colleague of his, with Judge Leonard Hand, who were saying, do you really think that the freedom of speech means that you should go to jail for protesting what the government is doing? Look at what our forefathers did. I mean, we were born out of revolution. So if there's any cause that should be protected by the First Amendment, it's political dissent. And I think that cut Holmes to the quick. That they were sort of subtly criticizing him on this issue. And so sure enough, in the fall of 1919, in a very important case, United States versus Abrams, he wrote his first powerful dissent that said, we really need to be protecting speech unless there's a clear and present danger.
So that's where that term comes from, is Oliver Wendell Holmes Jr.? Clear and present?
Well, actually, he rolled it out as in a case in the spring of 1919 as the test, but he applied it really toothlessly. He just said, oh yeah, because they sent these defendants sent these pamphlets to people that had been inducted into the army, calling this an unjust war and trying to say, don't go, don't join up. His clear and present danger test said, oh, that was a clear and present danger to national security, and therefore these people should go to jail. I mean, he rolled out the test in the spring of 1919, but he didn't apply it the way it sounded. And that's where he got that criticism during the summer, and that's where in the fall of 1919 he said, okay, my bad, we really need to start taking this seriously, that the government shouldn't be in the business of punishing people unless there is a clear and present danger of harm to the country that is worth rises to the magnitude that people can go to jail for their free speech.
So we're, in a sense, you and I and all Americans are children of Oliver Wendell Holmes Jr. insofar as our concept of free speech today is concerned.
Certainly he got the ball rolling, yes, although his colleagues didn't listen to him. So he was in dissent until he retired from the bench for the most part. It was only, so he left the Supreme Court in the early 1930s. And it was only until the late 30s, 40s, 50s, 60s that his colleagues began to say, okay.
He was right.
Yeah, now we're listening to both Holmes and Brandeis, Louis Brandeis, in terms of their powerful dissents on free speech.
I guess that's one reason. People ask, why write a dissent? Why write if you're the only justice voting against something and you've got 8 against you, why even write the dissent? Who's listening? But I think the people who are listening are the next generation.
Absolutely. And not only the next generation of people and lawyers, but also the next generation of justices on the Supreme Court. Because if they're being asked to apply a precedent in a modern case, they not only read the majority opinion from that precedent, that older case, they read the dissenting opinion. And a lot of times they'll agree with the dissent.
That's fascinating. Well, Holmes was, 4 or 5 generations after the founders, but I remember this from my civics class, probably in high school, in the late 1700s, John Adams was president. He is one of the founders. And so there's this Alien and Sedition Act that he pushes through Congress. So it seems to me that here's a generation that's responsible for the First Amendment. It says Congress shall pass no law restricting the freedom of speech, but yet that very same generation and this Alien Sedition Act, Congress passes a law that is trying to restrict political dissent.
They passed the law to do what Woodrow Wilson did in 1919.
How do you reconcile that philosophically? You've got the generation saying you can't do it, but they do it at the same time.
I would recommend to any viewers that want to sort of understand the phenomenon to go back to Leonard Levy's treatise, or I should say, he wrote a number of books about freedom of speech in the founding era, and he demonstrates that freedom of speech was a very narrow concept in the founding. So it was mainly designed to say that you don't need a license from the government to be able to publish your thoughts, as the early British government had done, and that was the main purpose of the freedom of speech clause. And there was a huge debate. The huge debate about whether the First Amendment was meant to abolish what are called seditious libel laws, which would throw you in prison for unduly criticizing the government or government officials. And so that wasn't even clear. That was a big debate. Levy, I think, thinks that there was a pretty good case that the First Amendment was not designed to outlaw seditious libel laws. And that's why John Adams was able to get Congress to pass a seditious libel law that would throw you in jail for criticizing.
So there was a philosophical, if not a legal, justification for the distinction to those folks in 17, whenever they passed the Alien and Sedition Act.
Oh yeah, I mean, they just didn't view free speech as being very free, and that's why when you read these modern Supreme Court decisions on free speech, the conservatives today they want to go and look at the original meaning of the words, the original understanding of what the Constitution was designed to do, and they do this particularly in gun rights cases, but in a lot of other cases too, like in Dobbs that overruled Roe versus Wade. But the one area you really don't see the Supreme Court paying much attention to historical understandings is these modern free speech cases. It's all about sort of these tests that the Supreme Court has just made up and are throwing out there that, in my opinion, are really just designed to sort of give a legal rationale for a balancing of interests that the court is trying to do behind the scenes. But there's very little discussion of originalism or historical understanding, and I think that's for a purpose, is because there wasn't a very broad conception of free speech at the founding. And so I think that's a real problem for originalist modes of constitutional interpretation, is that in a lot of areas, the way the founding generation viewed something is much different than the way we value or believe about things today.
So where we are currently, 2024 era, is this concept of free speech applies to the federal government, the state government, all the agencies and organs of those governments, but it doesn't apply to private business, private companies. And I think that's an important distinction to make. Let me know if I'm, again, drifting off center on this, but most people in this country say that we have the right of free speech, and it gets kind of vague and lumped together, says, well, you, Mr. Employer, can't tell me what to say because I have the right to free speech, but yet there's no constitutional prohibition against Mr. Employer or Ms. Employer telling me that I can't say something. Is that correct?
That's correct. I mean, so not just free speech, but all constitutional rights limit the way that the government can exercise its power with respect to a certain individual. It's all about the government. Now, the court has created some exceptions called the state action doctrine, where a private party can be considered to be a state actor for purposes of having to honor constitutional rights, but they're fairly limited. And so the general principle is the government is bound by the First Amendment, private actors are not, and they can do what they want with respect to free speech as long as it comports with laws that the legislature may have passed, or perhaps state constitutions might have something to say about it, but not really the federal constitution.
So pressures or restrictions on free speech in the private sector come about through generally economic or social pressures, or personal relationships, things of that nature, as opposed to demands or instructions from the United States government, which I'm not sure everybody understands. And of course, that's something that we're encountering today in the internet world, is because there's so much shouting going on. You would think it would chill private speech somehow, but it seems to result more in people not listening to each other. Instead, because to me, private speech or the freedom of speech is very closely related to freedom of thought. Because freedom of speech is like water to a garden, meaning freedom of thought. If you can't speak freely, it's hard to develop your thoughts. I was at when my younger son went to Boston College, and one of the introductory comments, one of the professors there was talking about how he considered himself to be an intellectual, and that he wanted all these students to become intellectuals. And his definition of an intellectual was for someone to listen to someone state a point of view, and then the person who had been listening say, yes, but, and then you carve out the exception, then the person sitting across would then respond, yes, but, and you go back through this, and I guess it's kind of like a John Stuart Mill's, freedom of discussion. John Stuart Mill, the 19th century British philosopher who was a huge proponent of free speech and talked about the marketplace of ideas and things of that nature. The idea is not to suppress, if there's a bad idea out there, it's not to suppress the idea, but it's to have more speech, is his thought process. But we're not there now. And I don't hear anybody, maybe there are, but it seems like no one goes yes but anymore. They shout back and they don't listen, and that certainly is not only my impression, but it's the impression of so many people. And any thoughts on why have we seemed to have degenerated into a anti-intellectual failure to have a meaningful discussion? All we do is shout at each other anymore.
Boy, that's the big $64 question. I mean, I've often thought about that. I mean, because it seems clear that for a long time we were willing to sort of discuss different points of view and sort of give people the benefit of the doubt that they were acting in good faith and they had sincere intentions. Today, it's almost turned into a competition. It's almost become sort of a tribal ideology. You're part of the tribe and you need to defend that ideology.
It's a good point. Tribal ideology. That's an interesting thought.
And it's like, okay, who's going to win now? Not how are we going to sort of figure this out and meet in the middle somewhere. And I mean, I'm not a sociologist, but it's a very interesting thing to me. I mean, last night on the TV you had Ron DeSantis debating Gavin Newsom, governor of California against the governor of Florida.
Yes.
And right out of the gate, I mean, DeSantis was calling Newsom a liar and Newsom was calling DeSantis a liar. It's just, it's appalling the level of our civic discourse, our public debate, even by our purported leaders, are engaging in. They're just shouting at each other and calling each other liars and questioning each other's motives, and it's just, I don't know why this has happened, and I just hope that we get through. I think we will get through it.
I had a conversation with a software engineer not long ago. He's in the tech world, and he was making points about algorithms. And, on the Facebooks of the world, Instagrams of the world, and all this sort of stuff, and was making the point that the algorithms are written in such a way to drive viewer content and viewership is that they only want to reinforce things that you've read previously, but do so in a very dramatic, aggressive way. So it identifies you with the tribal ideology. So it gets you to click on it. So another one, but that's all you get. So you don't get a counter point of view, and all it does is get everybody angry and forms up everybody into their tribal group. So to speak. So that, in a certain way, to me, strikes me as the internet being a threat to democracy. Because if that is true, if what this software engineer is saying, we're all victims of these algorithms that are forming us into these very hostile tribal groups. And that's, to me, terrible for democracy as we know it anyway.
Absolutely. And there have been those allegations and whistleblowers, et cetera. And I hope Mark Zuckerberg and others are sort of taking those things seriously and really looking at that. But yeah, it definitely is a threat to democracy. And but to pin it just on social media companies, I think is an oversimplification. Obviously that's a contributing factor to the extent that happens. But I mean, I think the internet is a classic dual-use technology. Social media companies are a classic dual-use technology. It can have very beneficial uses, as the internet has, the spread of communication and ideas and understanding and the spread of knowledge but I mean, it can have very harmful consequences too if it's misused, and so we just have to be vigilant to make sure that we're getting the most good out of it and minimizing the bad about it. And this isn't a modern problem. The founders struggled with this, with freedom for the press. The First Amendment in its inception was all about freedom of the press. The founding generation didn't have a notion about what freedom of speech meant. That was only in a few state constitutions, and James Madison sort of inserted that. But what you really saw in the state constitutions was freedom of the press. And that's because they relied on the print. It wasn't about the news media or journalism. That didn't exist back then. It was about the printing press and the right of any individual to be able to communicate. The theory was that if you're going to have a democracy and you're going to have servants that are running the government, purported servants, you need to be able to keep a check on them as the people, because they are doing your bidding. And the printing press was the way that you could sort of keep tabs, have that discussion and keep tabs on what the government was doing and sort of voice your approval or disapproval. And so it was all about freedom of the press. But back in the founding days, the press was extremely partisan, at least after George Washington, and even before that. Stepped down, and it was, it was really salacious. It was people were personally abused, and so the founders were well aware that the press could be misused. But in their judgment, those sort of evils were necessary to get the good, the sort of the fourth pillar of democracy, the ability to people to talk about issues of governance. And so they had to take the bad with the good. And I think that's the same thing with the internet, with social media companies. We have to take the bad with the good, but we have to do our best to minimize, the harms that flow and do our best to maximize the benefits of these new technologies.
There's, and this is somewhat reminiscent, I think, of the tobacco litigation once upon a time, but there's current litigation going on, very recent litigation, filed by the attorney generals of various states, including Bonta, Attorney General of California, but there's also private litigation seeking class action certification on behalf of various minors, pending in both federal and state court. And the allegations are that the social media sites have used their algorithms to improperly groom and recruit children, minors, to get addicted to their websites. And there was a hearing on this not that long ago in court here in Los Angeles, where against a challenge by the social media coming back to Section 230, First Amendment issues, and which at this point anyway, the judge has rejected. Said, no, this is going to proceed. We're going to get into the discovery phase of this to see if actually you have been using these algorithms to addict, if that's the right word, children to the site, which sounds very similar to the issues that were alleged against the tobacco companies against once upon a time. So if that's true, and because it's funny, following the money can be very corrupting, and there's nothing new about knowing that, but if that is true, then these social media companies are sacrificing our children in some way, because we all know, we've heard about the increase in suicides and depression, major depressive episodes with children, and it all seems to go back to about the time, particularly with phones, the smartphones coming out. And again, should free speech protect these social media companies from appealing to these minors and trying to recruit them to participate in the social media activities or get them addicted to it? I can't wait until I get that next click or I get that next little sign saying someone wants to hear from me. That kind of social media interaction. Any thoughts on that?
No, I don't think that free speech should protect that. That's more conduct than it is speech. And there is a big lawsuit. I think it's been joined by some 33 attorney generals. So this isn't just a red-blue issue. This is something where the states are actually coming together, suing Meta, over whistleblower allegations that indeed they have, particularly for Instagram, they've designed their algorithms to hook young people in order, to keep them coming back to get their more and more personal data that they then sell to their advertisers. So it's a money-making vehicle for them. So to the extent that those allegations are proven that they are purposely addicting kids on their platforms, I don't think that should be shielded. I don't think that's free. I think that's more conduct, similar to you can't use free speech as an excuse to harass somebody, constantly calling them and harassing them. At some point the courts are going to say that's not free speech. That's unwarranted conduct. And I think you have the same thing here. The difference between tobacco, of course, is you don't have a minor doesn't have a constitutional right to have tobacco. A minor does have some free speech rights. And so if in policing sort of these actions of these platforms, if the allegations are proven they're indeed doing this, they're going to have to be careful about how they draft the laws, et cetera, and the judgments or whatever, the injunctions a court might order. They're going to have to be careful because now they are treading on free speech ground in terms of the rights of minors to be able to use these platforms. But they're just going to have to be more careful about how they do it. But in the end, I just don't see an argument that, free speech should allow companies to do this.
Yeah. Well, it's almost coming back to good and the bad with the internet and so forth. It kind of reminiscent of beware of Greeks bearing gifts. There's a lot of positive to these minors, the way it's presented, because you had this instant communication, information, social interaction. But on the other hand, the Greek is sticking something in that horse to get inside the walls of Troy to get these youngsters addicted to what is provided. So, which kind of raises the question, and I'm glad you brought this up, because you said it's not like tobacco. There's not a constitutional right to use tobacco, but minors do have some. Yeah, I think you said some rights of free speech. But
yeah, the court has been very hazy about this, but definitely they have said that minors do have free speech rights, but they can be limited as appropriate for minors.
Well, what happens if we get to the point, and maybe we're there already, but you're looking at all the statistics with coming back to this issue of these major issues of mental illness, depressive episodes, suicides of minors, which many claim correlate directly to the social media platforms and having access to this. Would it be constitutional then to limit minors' access to social media sites if it is noted to be a serious health epidemic, like tobacco is a health epidemic? Could you say that children are restricted in some fashion? I don't know how you put that into a formula legislatively for the children's health and welfare, just like tobacco said, until you're age 18. You can't have unlimited access to social media sites. Would that be constitutional?
Well, if you're drafting laws that are targeting kids and their families, that would be, I think, not an approach that would be taken, because just the enforcement of it would be a nightmare. I mean, so I think the laws would be mainly directed at the platforms and what they can allow their minors to do and what they can't. I do think that if those laws are carefully drawn to try to be, as they call it in the law, narrowly tailored to address identified problems, then I think that they would have a good chance of succeeding. Unfortunately, our Supreme Court, and I do think this is very unfortunate, there are books out there with titles like Save Our Children from the Supreme Court. And those titles have emanated mainly from, you mentioned the Communications Decency Act. Congress put in provisions in there to have websites make sure they build in protections so that kids weren't gaining access or being subjected to pornography. And the Supreme Court struck that down, saying, you just didn't do a good enough job tailoring these laws, and it's going to keep porn from it's going to make it too inconvenient for adults to access this content, which they have a constitutional right to access. And there was a series of decisions like this, where the Supreme Court seemed to be siding with the ability of adults to, without undue convenience, access very questionable content over protecting children. And I just think that the Supreme Court got its marshaling of values in those cases absolutely wrong. And so I don't know what the current Supreme Court would do, but I think that if laws were drafted with a lot of intent in mind to make sure that they were not being too broad in terms of the restrictions and so forth on these social media providers.
Might pass muster.
Yeah.
That would, the so-called strict scrutiny test, probably.
Yes.
So yes, interesting. Well, with speech, we talk. There are obviously long-standing limitations on the right of free speech. I mean, the government, through the court system, does enforce defamation laws. So if you defame someone under the legal test, you can be sued and ordered to pay damages for that. You can't perjure. You can be convicted for perjury, so that's another limitation. In terms of calling for direct action or direct threats, the harassing, I think you mentioned, all various forms of limitations on speech, but so many of those are after the fact. What I mean by that, yes, you can go out and speak and defame someone, call them a felon when they're a not, or whatever you want to call them, but you pay a price for it at the end, and if that defamation charge is proven, you pay damages, which to me is a very different animal than the prior restraint of speech. So prior restraint, you don't even get to say it. And therefore your viewpoint might be suppressed, and that point never gets out there. I wanted to come back to another case that's pending before the Supreme Court. I think it's the Murphy versus Biden case. It comes out of the state of Missouri, I believe.
I think it's the Murphy.
Murphy. Yeah. It's an unusual spelling, I think, Murphy. Yeah. But it's going to be heard in the 2024 term as well. And the case, I think, was filed in the Western District of Louisiana, and the district court, meaning the trial court, federal trial court judge there, the way I read this was a scathing opinion, and the point was that representatives of the Biden administration had been contacting various social media sites, and we quibble about whether coercion was used or whether requests were made to take down dissenting points of view, and various things like whether you should wear a mask, whether there was a fraud in the 2020 election. It goes on. The opinion lists 8 or 9 things, all of which, according to the factual finding of the federal judge, says he felt that there was a high degree of potential success, that the plaintiffs would show that members of the Biden administration had contacted the social media sites and succeeded in having them suppress dissenting points of view on a whole variety of things, and issued a preliminary injunction. And some of the language that this judge used was astounding. He said, if these allegations are proven, it's arguably the greatest transgression of the rights of free speech in this country ever, and issued this injunction against the Department of Justice, the FBI, the Department of State, and others. And then it goes to I think Louisiana's in the Fifth Circuit, so the Fifth Circuit affirms that injunction, but limits it, I think, on the language.
To certain parties.
To certain parties. And then it goes up to the Supreme Court. The Supreme Court has taken the case, but then also took out the injunction on, I believe.
They stayed
the injunction, yeah.
Until they could hear the case.
Hear the case. And of course, that's very timely because 2024 is an election year. And so this is, to me, is a huge threat to democracy in this country, because if you have the sitting administration is able to call up the social media sites indirectly or directly, where tens of millions of people get their news, and make our suggestions or coercion, says, don't carry this dissenting point of view because we don't want you to for political purposes. How can you have a functioning democracy if that's allowed?
Well, you can't, and I think these allegations there's been a lot of hype, I think, surrounding it. I think this was mainly about the Biden's attempt. we'll see when it gets to trial. But from my cursory reading of the papers, is that this was mainly about the attempts of the Biden administration, including CDC officials, to reach out to these platforms about views about vaccinations, the effectiveness of vaccinations and masks during the pandemic, and they thought that they were spreading misinformation, disinformation. And so, so I think the government has every right to, call up Instagram or Facebook and say, were you aware that there's this post that's getting a lot of hits that seems to be counter to prevailing scientific consensus? Stop. They can do that. But what they can't do is go on and say, if you don't take that post down, you're going to suffer reprisals from the government.
Well, that's kind of the distinction between making a request and using coercive tactics. But the problem with the people who are making the request have the power to regulate and tax, which is the power to destroy. So, it strikes me that a simple request is the equivalent to coercion. I know in the scholarly areas, they'll make the distinction based upon there's a difference between making a request and using coercive tactics. And that's a legitimate point. But when the person making the request has the power to destroy your company, then it's a very fine line, it seems to me.
Perhaps, but the government does have the right to speak itself. The Supreme Court has recognized that there's the right of the government to express its viewpoint. Look at the president when he gives a speech. He's expressing certain viewpoints, and we have to have that to have a viable form of Republican democracy. I just don't see any problem with a CDC official, for example, reaching out and say, can you look at this post? We don't think it conforms with scientific consensus. But it has to stop there. Notification. If there's any sort of threat of reprisal on tax issues or whatever, then I think the government should be in hot water. But the allegations here are that they were being threatened. The Facebook operators or whatever platforms are at issue were being threatened and actually under the actual control of the government.
That's kind of an aiding and abetting type.
I find that hard to believe, but if that's proven, and I'm not taking any position until the proof is in. If that's proven, then the government is clearly violating the First Amendment. You can't take a private actor and make it an agent of the government to do something that the government can't constitutionally do. That would be a blatant violation of the First Amendment. They know that. That's why I would be shocked if these allegations prove to have any merit. But I think what the Supreme Court is going to do in this case is just, they're going to see what the facts are. But if they are, as I sort of suspect they are, that the government was perhaps, contacting them in a way that perhaps could be viewed as sort of intimidating, I think the Supreme Court is just going to use this case to send a very clear message to the government. You got to be very careful in the way you do this. But they did lift the stay. On those lower court orders.
Like a 5-4 opinion, I believe, wasn't it?
Well, three of the justices, the far-right justices, Alito, Thomas, and Gorsuch dissented. But the bulk of the justices were receptive to the views of the Solicitor General that this is really going to chill productive communications of the government, between the government and these social media platforms. And I think that the Supreme Court was receptive to that. Obviously, they had read all the papers. And so if they thought that if the 6 justices in the majority here had thought that there was something really serious and nefarious going on here, I don't think that they would have lifted the stay on these lower court orders.
Well, Kagan joined the dissent, but without an opinion, so we don't know what Kagan's thinking was, I believe. I think it was a 5-4. So you had the 4 justices plus Kagan, but Kagan just had a separate dissent, I don't think, signed on to any dissenting opinion. So it's 5-4.
I'd have to go back. I didn't see that, but I'll have to go back and look at that.
So I guess what's before the Supreme Court then on this Murphree case is it's not going to be a factual determination, because I don't think the case is ready, but it's a legal determination. So maybe the most we can hope for is the Supreme Court will give us some kind of test on what would be permissible contact from representatives of the federal government to the social media sites. That's probably the best we can get out of that, I think is what...
Yeah, I mean, I think the law here is pretty easy. Everyone knows that the government cannot coerce a private speaker to censor the speech of somebody else. That becomes government action, subject to the First Amendment. And so I don't think there are going to be any major pronouncements in the law here. I think it's going to be just mainly an emphasis on the law, but really sort of this is going to come down to, okay, let's see what kind of facts and circumstances can be developed here.
Well, you mentioned also disinformation, misinformation. I think the distinction most people get with misinformation is just a clueless misstatement of the facts, where disinformation is intentional misrepresentation of the facts. This is my problem. Who decides what's misinformation or is disinformation? That's Big Brother stuff from George Orwell's 1994, because we look back over the last 3 or 4 years. You take Anthony Fauci, he first said masks are no good, then he switches gears and says, no, you got to have a mask. So was he giving us disinformation, misinformation the first time, or is he doing it the second time? It's the same thing with the first the theory about the natural, the COVID virus coming out of China from a wet market that had to be accepted. Anybody suggested it came out of the nearby lab was all disinformation, misinformation. Everybody who said that was shouted down. Now, most people think that it is in fact coming from the lab, not from the wet market. The same thing with Hunter Biden laptop. That was all shouted down as being Russian disinformation. And I think there's 52 people from the intelligence community signed on to that and said, yeah, it's all disinformation. But now we know it wasn't. It's true. And so who decides what's misinformation, disinformation? Because it's the government. If it has the right to decide something is disinformation or misinformation, therefore it should be suppressed, then we don't have a free speech in this country. If that's Big Brother stuff, is it not?
Yeah, I mean, when we're talking about misinformation or disinformation, we have to distinguish between, free speech is, you can break it down into 3 broad categories: opinions, ideas, facts, factual statements. There's no such thing as a false opinion or a false idea. There may be bad opinions. There may be bad ideas. But, facts. Is it objective reality or isn't it? And who decides what the facts are? Well, I think sometimes we can all agree on certain facts. The sky is blue, when the sun is shining, or the sun usually rises in the morning in the east. And so if somebody says it isn't, I think we can say that that's misinformation. That's sort of what judges call things that you can take judicial notice of, things that are sort of just taken as a given fact. But then, there are other things that you need consensus, and particularly sometimes scientific consensus, sometimes other consensus to call something a fact. So it tends to be opinion that morphs into fact as more consensus coalesces around that. So it's a very, it's a spectrum, right, in terms of what misinformation is. And who decides? Well, certainly government agencies and bureaucrats cannot have the last word on that, but they can certainly take a position that this is counter to prevailing scientific consensus. And then if you want to challenge that, then you should have the right to get in front of either an administrative tribunal, maybe an administrative law judge, or in the end, a court of law, a federal court with a jury. In the end, I guess the jury is the ultimate arbiter of whether something was a misstatement of fact or not, because the jury is often decides those issues and decides what the facts are.
That's classic Americana. I think we're the only country that probably does it, but certainly to the degree that we do it through a jury. Let the people speak. I guess that's the most direct democracy we have.
Well, the founders certainly viewed the right to jury as one of the pillars of democracy.
Well, isn't that, coming back to this misinformation, disinformation, who decides? Is it Big Brother? Because over the last 3 or 4 years, we've had the government, or quote, Big Brother, telling us one thing we know is not true, but yet at the time that people who took a dissenting viewpoint were suppressed. So if you take this Murphy case, and if those allegations are proven, that because of these indirect coercions or suggestions from the government, these sites were taken down, that's probably a restraint of speech to me. It seems to me, and let me know if you agree or disagree, but the better approach to this is rather than suppressing speech through prior restraint, it's to have some kind of disclaimer on everything, whether it's coming from the government or private speakers saying every reader should consider the facts, think for themselves. There are dissenting viewpoints, but take it all into consideration. They need to hear that. That's what John Stuart Mills would say, I think. It says the cure here is not, the answer is not suppression of speech, it's more speech. I mean, what's your thought on that?
Well, no question that if you think that there's problematic speech in terms of being misinformation or disinformation, the ability to raise a notice or a red flag to, this has not been verified would be the preferable way to go. And in disclosure requirements, well, here again, I mean, you have to distinguish whether a platform voluntarily adopts those and it's their right to do it as long as it's in their terms and conditions, or whether the government is
well, that gets us back to the contract issue you were saying, or whether or not they're a public forum now. Which I think that's a Texas case, the net choice. That's the issue that the Supreme Court's going to have to wrestle with, right? So can you contract away if there's a constitutional right for the user to speak? Can you contract that away? I mean, can you contract that away if you sign up for a right to use a media platform?
Oh, no doubt. Yeah. I mean, so if your terms and conditions say that I agree that Facebook or whatever social media company can moderate, curate, remove my content for whatever reason it deems advisable. I mean, you've agreed to that, even though you might challenge it and say I didn't really agree to it, even though I clicked on the terms and conditions. There wasn't mutual assent to a contract.
It would be kind of an arbitrary and capricious kind of requirement. You get these on these so-called adhesion contracts that with the insurance policies, that kind of thing. Yeah, we signed the document on the dotted line, but we didn't have any choice. That's the argument, I suppose.
Yes, and so you can attack it on those sort of contract defense arguments, as a contractual matter. But as a free speech matter, again, unless it's the government that is either forcing the social media companies to do this or punishing people themselves for what they say, you really don't have a free speech, at least a legal free speech complaint.
Well, that's the issue about the contract is just, to me, is fascinating, and I did not realize that you could contract away a contractual right if it's really an arm's length contract. I think is if it's a contract of adhesion, that's a subject to proof, I suppose. There may be who knows, might be a class action out there someday that's going to challenge that.
Well, there could be public policy arguments that, we should abide by free speech norms and so forth. And so if a contract is ambiguous, maybe that would come into play or something. But I mean, so if a contract were to say, you not only agree that we can censor your speech, but that the government can come in and tell us to censor your speech, that would not be waivable. You generally can't waive your constitutional rights. I mean, well, you can in certain circumstances, but it's very murky. But we're not talking about that. We're talking about a transaction between two private parties, one a company and one user signing up for their terms and conditions. And so it's really it's viewed as a consensual transaction, even though that's a fiction because no one ever reads those things, but that's how it's administered under the law.
I bet there's a good chance that the Supreme Court justices who partake of social media probably never read those contracts either.
Oh, who does? I mean, yeah. Yeah, unless you're writing a law review article about them and then your eyes glaze over when you're...
Well, Professor McDonald, this is a fascinating subject. I'd love to have you back sometime to even expand on this, particularly as the election year goes forward.
Well, thank you, Roger. It's been a very enjoyable and interesting conversation.
I've enjoyed it very much, and thank you.
Thank you.
This is Roger Clark, your host of the Fourscore and Seven Project. If you've enjoyed this program, be sure and like and follow us on our podcast. I hope you have a wonderful day. Thank you for watching and listening.